A magistrate court in Abuja has remanded Professor Duke, Zainab, Abiola and her housemaid in Suleja Correctional Facility, Niger State, over allegation of assault on a policewoman, her orderly. The magistrate's ruling on application for bail said the court does not have jurisdiction to grant bail for the crime committed by the suspect, thereby remanded them at the correctional facility in Suleja. However, the magistrate read the charge to the suspect that on the 20th of September 2022, Professor Zainab asked the police officer to wash her car carpets. The officer told her she cannot do that on uniform. Out of anger, she used a metal object to hit the police officer on the head and asked her house help to join her in beating the officer, who was later rescued by passers-by. Counsel to police and suspects have this to say.
Appearance in the court was for the Commissioner of Police, who is the complainant in this case. Commissioner of Police FCT Command.
Okay, can you tell us what transpired in the court?
Well, today is just for arraignment, and what's transpiring in the court today is just an arraignment. The defendants was arraigned on the 5 counts. Only the court was, because there are procedural laws and there are substantive laws, which seems not to be agreeing with each other. The substantive law under which we arraigned the defendants expressly stated that the courts have jurisdiction. But the court was a bit convinced with the substantive law, and that was why the arraignment took place today. And that same substantive law states that the offense is not bailable. I'm talking about Section 229 of the Penal Code Law, which provides for offense of attempt to commit culpable homicide. It was expressly stated under the procedure that it is not bailable. And that same procedure confers jurisdiction on the Chief Magistrate Court to entertain the case. So,
do you see continuation of this case in this court from the argument?
Yes, if we are to rely on the substantive law, which with all intents and purposes there is none. There is no any procedural law that have stated otherwise, because the CPC that the court consulted seems not to be applicable here. What ought to be applicable here is the ACJA, that is Administration of Criminal Justice Act 2015. That's what ought to be applicable here. But there's a provision that says that if the ACJA is silenced as regards to jurisdiction, further consultation can be made, and that's what the court just did. If I'm to state my own view, I will say that there's nothing that deny or deprive the courts of jurisdiction to entertain the attempt to commit culpable homicide, as far as the law, as far as the Penal Code Law is concerned.
I think this is the ordinary course of justice. It's not all the time you come to court and get what you want. And this is just one other case. The judge considered the circumstances of the case and decided one way or the other. She decided on her discretion. It's within her powers to do so.
Okay, there was an argument of jurisdiction. Do you think we can pull through in that argument?
The argument of jurisdiction, as you know, is a question in the court. It is not for me to discuss it here. It is something that will remain in the courts. We would have to discuss it in the next sitting.
So what are your expectations?
My expectations are that justice will be served. My client is innocent. I know she is innocent. There are allegations, but we will see as the outcome at the end of the trial.
Thank you very much.
My name is Barrister Hassan Yusuf.
Thank you.
Thank you very much.